two clarifications. I'll be very quick that I'm seeking. There has been a lot of use of phrases such as kaende kaende, wenye wivu wajinyonge, and other terminologies that sound abrasive, harsh, and insensitive. I would be asking Mr. Speaker for clarification how those are grounds for impeachment, if they can tie them to either committing a crime, abuse of office, physical or mental incapacitation. My second clarification, Mr. Speaker, is we have so many from both parties, but this one I pose actually perhaps to both. We have a lot of evidence that has been submitted here in terms of exhibits in support of the impeachment motion, and they're quoting social media, WhatsApp messages, Facebook, and the likes. My question would be for clarification, has this evidence actually passed through the legal process of authentication, legally known as the chain of custody, so that we can be sure that what we are referencing is actually the legitimate evidence? And is it possible to get the context of these screenshots? Because we are in the era where there is a lot of misleading. So perhaps if we can get the context or the full, instead of just giving a screenshot of partly of the message. And finally, Mr. Speaker, did you actually get consent for any social media exhibits that you've posted here? As you know, for instance, in WhatsApp, the data processor, the data manager is the administrator. Did you get consent to be able to table these alleged exhibits to support?
Proceed, Council.
The first question, Mr. Speaker, is whether vilification is a ground of impeachment. It is, because under the laws we've presented for the relevant count, public officers, including governors, are supposed to behave in a manner that brings honor and dignity to their office and the office of other public officers. They are legally obliged to refrain from bullying and vilifying. And these are Chapter 6, Mr. Speaker, laws I'm talking about. Someone was just opening them for me. Perhaps once it is open, I'll show it to you. There is a question of whether we can rely on WhatsApp, Facebook. The world moved a long time ago from that traditional hostility towards electronic evidence. As a matter of fact, Mr. Speaker, these days even legal documents are served on WhatsApp. You check with the judiciary, WhatsApp is a recognized method of sending and serving even official summonses and court orders and whatnot. There is legal provision, of course, for our electronic evidence is to be presented. The requirement is one for authentication, and all you need is a certificate. We have presented that certificate in the affidavit of the mover of the motion. It identifies the devices from which these WhatsApp screenshots, Facebook, whatever, were downloaded. So all you need, Mr. Speaker, is to show the path and the device. And just for the record, we have those devices before the Senate. Should the Senate be interested in verifying whether indeed those WhatsApps were downloaded using those devices as required under Section 106B of the Evidence Act, or if you like, Section 78A of the Evidence Act. Is it possible to get the context of these screenshots? Of course it is, perhaps with or without some difficulty, but we tried during the evidence in chief to show you that the governor was actually trying to misrepresent the context by misleading you to believe that the procession we saw the deputy governor participate in September is the one that triggered the WhatsApps, when the WhatsApps have their own timestamps and date stamps that show they occurred several months before that and unfortunate incidents. Do we have consent? No such consent is required. And while still on this question, Mr. Speaker, we said early in the morning, the prevailing jurisprudence is that the proceedings before you are not akin to proceedings in a court of law. So those three